Good afternoon. Bresco and Lonsdale contracted in 2014. The adjudication, which started their journey towards dispute resolution, took place in June 2018, or at least it started then. Proceedings then followed and hearings in 2018 and 2019. I doubt if anyone at that stage had any thought about a global pandemic. As we all know now, COVID-19 intervened, and the last round of the journey, or the most recent round of the journey, ended up in the Supreme Court in April this year and has resulted in a very speedy judgment being handed down by the Supreme Court last week. That speed is probably an implicit recognition of the importance of the issues that the decision raises, given the global economy being in freefall. There is simply no other word for it. And issues of insolvency and adjudication are key. We have pulled together a panel from members of chambers reflecting the cross-specialization interests that are engaged in litigation involving insolvency and adjudication. We've got David Sawtell, who specializes in insolvency matters and construction matters. We've got Philippe Kuhn, who is just simply very clever, and every panel has to have somebody like that. And we have Shaman Kapoor, who has been brought in because he deals both with civil liability and commercial matters, but has an overarching interest in costs. And as we know, that is also one of the key factors that is going to be under consideration. We invite you all, please, to submit questions through the Q&A box, if you'd like to find where that is on the screen you're currently using. We've also opened up the chat box, which we would like to be used when we carry out some polling. I'll give you due notice. We will be asking you to answer one or two questions with a simple yes or no. But against that backdrop, can I in fact now ask Philip just to tell us what the legal position was before the Supreme Court decision and what effect that had had on adjudication generally, insofar as we can work that out.
Thank you very much, Marion. I thought I'd sketch the background against which the Court of Appeal and then the Supreme Court came to their decision a little bit more fully as well. As you said, the dispute itself dates back to 2014, and an important point relevant particularly to the jurisdiction argument, which was rejected in both the Court of Appeal and the Supreme Court, was that the construction contract between Bresco and Lonsdale incorporated the language of Section 108 of the Construction Act. So it said any dispute arising under the contract. There was a claim and a cross-claim after Bresco became insolvent in 2015. And for anyone interested in the breadth of the relief sought, that's set out at paragraph 6 of Mr. Justice Fraser's decision at first instance. And the other important background point is that Bresco concerns an insolvent liquidation where there's no suggestion that there was any fault on the part of the paying party. And that's perhaps a point that David and Marion will pick up later on. The Court of Appeal reversed Mr. Justice Fraser's decision. Mr. Justice Fraser had accepted both the jurisdiction and the futility arguments presented by Lonsdale. The Court of Appeal, in a judgment given by Lord Justice Coulson, with which the other members of the court agreed to continue the injunction restraining the further conduct of the adjudication, but only on the futility ground, and that's really pre-Bresco in the Supreme Court where the main interest was. And Lord Justice Coulson's key basis for that decision, apart from a concession point which we can return to later perhaps, was the existence of what he called basic incompatibility between adjudication and the regime found in the 2016 insolvency rules. As a point of reference, both in the Court of Appeal and the Supreme Court, no great significance was attached to the slightly different provisions found in the 2016 rules. So the reasoning should hold pre and post. And Lord Justice Coulson said that adjudication is a method of obtaining an improved cash flow quickly and cheaply, whilst he saw the purpose of the proof process in insolvency to be an abstract accounting exercise. And primarily on that basis, he considered that there was a futility in parties proceeding to adjudication where one of them was insolvent. And the other point highlighted by Lord Justice Coulson was the wasted expense on the adjudication that would be involved and the burden of these applications, particularly at the enforcement stage, coming to the TCC. And those are points that weighed heavily with the Court of Appeal. And I'll leave David to comment on what the Supreme Court made of those. Essentially, the same arguments were taken up by both parties with an appeal and a cross appeal. Before I come to that, or rather I leave David really to deal with how those arguments were developed, there were two significant decisions between Bresco in the Court of Appeal and the recent decision of the Supreme Court last week. And they'll both be familiar and they'll be discussed in some detail, particularly the first, which was Meadowside Building Developments Limited and 1218 Hill Street Management Company. And in that judgment, Adam Constable QC gave quite a full treatment and began to see some room for exception to the Court of Appeal's reasoning on futility. And then the second case of interest is Balfour Beatty Civil Engineering Limited and Aztecs Projects Limited. And in that case, Aztec had been in liquidation. And really the point that I take from those two decisions is that there was already some appetite for what the Supreme Court then adopted, at least in narrowly defined circumstances. And Shaman will particularly pick up on the funding and championship aspects of the decision in Meadowside, which will be of wider interest and no doubt an evolving area. And David will deal with the particular issues at the summary judgment and stay on execution stage. I think at this stage, that's all I can usefully say, but I'd be very happy to take further questions.
Now, I think that's my cue to take over and look at what the Supreme Court actually decided. And there are two parts in respect of Lord Briggs' speech. The first, respect of jurisdiction, and the second, in respect of utility, or perhaps even futility, in trying to bring an adjudication if you have an insolvent referring party. And as we saw, the jurisdiction argument didn't have much weight in the Court of Appeal, but what Lord Briggs, the actual comments he made about jurisdiction in the Supreme Court are very, very interesting. But ultimately, the question is about insolvency set off. Once a company goes into insolvency, then the creditors have to claim in the insolvency. And they might, if they're unsecured creditors, they probably will not recover everything. However, it's always been the case that if they have a cross-claim against the insolvent company, they can set this off against the insolvent company's claim without deduction. So essentially, you have the full value of your cross-claim insofar as it might exhaust a claim by the insolvent company's claim. So that's insolvency set off, and you saw that in the Insolvency Rules 1986, you see it in the Insolvency Rules 2016, and you see it in a number of different insolvency regimes across the world. The issue, though, is what is left. What is left of the underlying dispute? Is it a claim about that dispute? For example, under a construction contract, which you can refer to adjudication? Or is it a claim about a net balance, about what the different parties owe to each other in respect of the insolvency set-off and an account? And if it's a claim in respect of a net balance, then it is no longer arising out of a construction contract. We no longer start to see the source of jurisdiction that you might be able to refer to an adjudicator. And it was this which exercised Miss Justice Fraser in the High Court. So the difference in opinion between the TCC, the Court of Appeal and the Supreme Court all turns essentially on the different interpretation of insolvency set off. And Lord Briggs decided that, yes, you can refer the underlying dispute to adjudication, and that is left. What the resisting party has been relying upon was a House of Lords case called Stein and Blake in 1996. And what that case is authority for is that the separate cross-claims themselves cannot be assigned. But going on in the speech in that case, it was clear that some things did exist and did continue to exist. So, for example, it was possible to refer a dispute to arbitration, even though it was being referred by an insolvent company. And Lord Briggs essentially went on to draw the analogy between adjudication and arbitration. If you can refer a matter to arbitration, a dispute to arbitration, then surely you can refer a dispute under adjudication, which looks like a very neat analogy until you come across the whole plethora of jurisprudence questioning whether it's appropriate to draw that analogy. But ultimately, what Lord Briggs says was, yes, you can refer the underlying dispute to adjudication, therefore the adjudicator would have jurisdiction to deal with it. And he made comments that a liquidator may choose to refer some disputes to adjudication, some to arbitration, and use different forms of ADR for others. And let's not forget that Lord Briggs, throughout his career, has in the judiciary has been very much in favour of alternative dispute resolution. But the utility aspect is probably what surprised construction lawyers, because we all know from Wimbledon and Vago, all the way back from cases before that, was it would be quite usual, and it'd be in fact be very unusual, if an insolvent company was able to get a money judgment which is not stayed, and so was still enforceable in a matter arising out of adjudication. As we know, adjudication is binding, but it's temporary. What if you then went on to win the resulting litigation or arbitration? How could you claim the money back from the winning party, the insolvent party? But Lord Briggs was not convinced by this argument. He said it was inappropriate for a court to interfere with the exercise of a statutory and contractual right. Injunctive relief would only very exceptionally be granted, and saw a dispute resolution being an end in itself, even if summary enforcement is not open. This would be a question that's postponed to the enforcement stage. So you could refuse summary judgment, or you might very well grant a stay of execution, or, as we're going to go on to see, in a murder-side case, the liquidator may give appropriate undertakings. There's a massive footnote to what is being said there, however, because only very recently in Grove Developments, the Court of Appeal said there could be a fetter on the right to adjudicate. If, for example, there has been an adjudication on a payment notice dispute and the losing party wants to refer the valuation dispute to adjudication, then the Court of Appeal, as Rupert Jackson was very clear, you should pay first before you adjudicate the valuation dispute. So immediately there might well be an inconsistency, and one might very well think there is an inconsistency between the payment notice regime under Part 2 of the Construction Act and the need for to make interim payments, and this idea that you can refer matters to adjudication even though the party is insolvent. But I think that's probably something we're going to discuss later on, or probably even on another day. And I'll hand over to Marion to discuss, are we, however, surprised by the Supreme Court decision?
And yet again, I was that participant who was on mute and didn't realise it, for which my apologies. I am unerringly that person. Let's just get a poll, because David was very clear, I think, that he was surprised by the decision on utility. And I would be very interested, could I invite you all, just either yes or no in the chat, were you surprised by the Supreme Court decision on utility? Yes or no? Very interested to see if anyone's prepared to tell us. Thank you. Thank you. So far, it's coming out, what? Yes, no, 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 yes, no. Any more? It's pretty split, isn't it? That is interesting. Any more views? Definitely not one approach on that. Can I just check? Because I don't think David and I were surprised by the decision on jurisdiction. What's your view on the decision on jurisdiction? Jurisdiction, were you surprised by that one? Were you surprised by the decision on jurisdiction? No, far more unanimity. Yeah, 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 that fits. It seemed to me very clear that on jurisdiction, they were facing an uphill battle. And I was not surprised at all at the decision that was reached on that. But one thing I really do want to stress, and a large part of my job seems to me to be saying the legal equivalent of don't drink bleach. We have to remember to read the contract, because the decision in Bresco, in part, turns on the wording of the contract. The right to adjudicate, as Philip has stressed, mirrored the statutory right, and it was any disputes arising under. The court, interestingly, the Supreme Court ducked yet again that question as to whether or not the Fiona Trust approach to reading an arbitration clause directly applies to an adjudication clause. I would have been quite interested in if they decided, because everything you read is split and you can find an authority for either proposition, but they ducked it and took the very clear line that in fact they'd taken throughout the argument, it being very clear that this was such a good thing, then it was inconceivable that there would be a narrow right to adjudicate such as was being promulgated. So I think that on the jurisdiction, read the contract, but it's answered the question. On the utility, I think that I was initially surprised by it until I sat back and looked at the makeup of the panel. And in many ways, you're playing to a prejudice of our lay clients who believe that everything turns on who the individual judge is and who the individual arbitrator is. Indeed, you could say a belief in the importance of the identity of the arbitrator is one of the main factors that leads to the use of international arbitration. But when you saw the approach that the Supreme Court took and the predominance it gave to dispute resolution in itself is a legitimate end, and its preparedness to skip over the other major distinction, I thought, that perhaps had driven the Court of Appeal's approach. We mustn't forget that Bresco on its facts is a small sector of the adjudication business. It is one of those disputes where everything was in the adjudication. As Philip has stressed, there were, I think, 7 or 8 separate heads of relief sought, all the way from, had there been a breach, was there a repudiatory breach, who had the right to terminate, into the damages. So everything was being dealt with at one end. That is very close to the insolvency set-off adjudication of all the disputes. The other end of the continuum is the smash and grab. And if you go back and reread what was being said in the Court of Appeal in Bresco and in the 2 subsequent first instance decisions, there was a clear recognition that the smash and grab adjudication might in fact be a very different kettle of fish. So that's where I've reached on it all. What do I now expect that's going to happen? What effect do I now envisage it will have? I think we are going to see increasing use of adjudication. Can I just check with the panel, what was your feeling? Had Bresco in the Court of Appeal inhibited liquidators in using adjudication? David,
Absolutely.
do you have spoken? Yep.
Absolutely. When you look at what the original TCC decision and you speak to insolvency practitioners at that time, it was a bit worrying because there were a number of disputes that were being referred to adjudication. It was quite a practical tool for insolvency practitioners in construction disputes. And I think Lord Briggs picks up on an overall anxiety in that professional sector that suddenly a very useful tool was being denied to them because of some concerns about some adjudications. So we might go back to a state of mind that's more pro-adjudication in the appropriate dispute.
I was also interested in the way Lord Briggs equated adjudication with early neutral evaluation. And I'm just wondering, do we have any feel for the extent to which, as an industry, early neutral evaluation is being used? My anecdotal impression is that it's very rarely used. David, have you come across it being used?
No, no. I think early neutral evaluation, it's difficult to talk in a post-1996 world where it's so easy to refer things to adjudication,
Yeah.
and then it's binding, but it's temporary. But even in other commercial settings, it's not the usual form that it might take, as for example, it might in a chancery dispute, where the chancery division has been very keen on promoting early neutral evaluation, even by the judiciary in front of masters and high court judges. So it might be it's something that's come out of Lord Briggs's background in the Chancery Division.
Well, TCC has had a scheme. I think it was one of the earliest to adopt it, but the last time I looked at the stats, it was very low take-up. David, can I pass on to you? What's now going to happen at the enforcement stage? Because that's where the battleground is being shaped and directed. What do you see now happening at enforcement?
Absolutely. I mean, what I think the Bresco series of cases from TCC, Court of Appeal and Supreme Court has done is to throw up new lines of defence for the resisting party. And first of all, they're going to be looking at the question of a stay and going down the Wimbledon-Vago principles and the little nuggets in there that say if you have a party in formal insolvency procedure, then you're most likely going to get a stay of any judgment. I think also there's going to be a scrutiny now of the insolvency set-off angle to see whether or not there were disputes which could not have been brought within the adjudication, but which now you might think about bringing as a cross-claim. You might try and think, well, actually, you can't enforce this judgment because I have this cross-claim. That hasn't been run so far yet, so we might have a look and see if that becomes a fashionable line of defence. I think we're going to be looking, and I think we'll go on to considering that in due course, looking at a funding arrangement. How on earth has this insolvent company funded an expert report, got lawyers, got claims consultants, run it all the way through to adjudication, paid his issue fee in the TCC, and is now sitting in Microsoft Teams asking for its claim to be enforced? There'll be questions raised about that, and it'll be interesting to see hear from Shaman as whether those questions will be answered, particularly in referring back to what Justice Fraser in the Court of Appeal said in Eigen and Gosner, that if a question is asked, and it's a fair question at the enforcement and at the stay, question of an application for stay, and the material is in your possession, but you choose not to hand it over, then when is the court in a position to be able to draw adverse inferences from your refusal to, for example, give a copy of your funding arrangement, which you wouldn't normally expect to see, but because it turns to issues of, for example, championing abuse of process, was going to consider, I can see being grounds. We look at Bresco alongside Eigen and Gosner for all kinds of litigation by correspondence, and I say more lines of defence for a resisting party.
That I think segues nicely into Shaman, because we do, whenever we look at Meadowside, we do hit the Champathy argument, we do hit the funding and the ring fencing arrangements that were put in place. Costs comes very firmly into the centre of stage. What do you think, how are liquidators going to fund these obligations and fund these adjudications?
Thanks, Marion, and good afternoon to everyone. It's a fascinating topic, especially for someone who frankly knows very little of the detail of your industry, I should say, and I come in from a sort of satellite approach. I think before answering that question, which is obviously what I'm going to deal with, there are some really interesting nuggets that I have absorbed as I've prepared for this seminar. Firstly, who could ever have believed that such an arena would be not costs bearing? And that perhaps also answers why I have little experience of the arena too. I find that incredibly fascinating. as much as I do, that most of the decisions that are given often not by a lawyer, that they are often taken to be final decisions, and that only, I'm told, or at least I read that it's reported that only 2% of the decisions come to be challenged in the courts. All of that, I think, does have a bearing on the question that you ask of me. And the other thing that I picked up is that whilst the jurisdiction of the adjudication is not cost-bearing, there is a little provision in section 108A that allows the parties to agree for the proceedings to be costs-bearing, but after there's been the service of the notice of intention to refer a dispute to adjudication. So that's quite interesting, and I wonder how that will play out. I'll hopefully come back to just round on that point. The other things that I pick up away from the adjudication process and more from the insolvency angle is this concept of expenses, liquidators' expenses. And it seems that the expenses incurred by liquidators, which must include the expenses of engaging lawyers, that is deemed to be proper liquidation expenses that would be recoverable within the scope of liquidation proceedings. So that is, I think, another interesting aspect that begins to paint the picture on this question that you ask me. And then briefly to mention Meadowside again, a very, very interesting case. And I know that you're fascinated in particular about this kind of failure to answer the factual questions that were put on the party, the receiving party, or the party making the claim in relation to its retainer. And it's quite interesting because I think the approach there has perhaps been borrowed from the costs jurisdiction, whereby if you have a genuine concern about a retainer, you have to first establish an initial threshold before which time the burden shifts to the other side to make disclosure of the retainer, or in the costs court, provide a statement that sets out the call terms that have been brought into question of the retainer with a statement of truth and set it out. Or you do what they did in Meadowside, which appears to be to do nothing but accept that there will be adverse inferences drawn from that. And I think that is, again, a particularly important aspect of all of this. I know I still haven't answered your question, and I know that won't be lost on any of you. But one more point that I want to pick up on in the round as I build up to your question. The Balfour Beatty case interests me from my satellite position, I suppose, because I note there that Aztec were able to provide security through an insurer, and that turned out to be security. So this is at the point of enforcement, as I'm sure you will all know better than me, but they provided security through an insurer at 3 times the level of security that Aztec held itself. And as a part of that process, the policy of the insurance had to be reworded, and Balfour Beatty in that process reserved the right to seek further security. And that resonates with me on applications for security for costs in the civil jurisdiction, the way in which that was approached and the sorts of conditions. I need to say nothing more about Bresco because of course, that's what we're here to talk about. So I translate all of those little tidbits, if you like, and come to this. Bresco is obviously going to encourage liquidators of insolvent companies to seek to recover debts. And such an exercise is clearly only going to be restricted in very exceptional circumstances. And the Meadowside approach to protective measures is there as a mechanism and is available at the enforcement stage. But for your client base and for the people that I think are listening to this seminar, watching the seminar, I think liquidators now become an even more important client and potential client. And even if they are not a potential client, they have a very unique involvement if they are an opponent. And so the question is, as you asked perhaps now long ago, how will liquidators fund these adjudications and subsequent enforcement proceedings? Well, I think the first thing that we might expect liquidators to do, and in my experience, they're particularly well versed in litigation and litigation funding options. But I think one of the things that we would expect them to do, or expect to see them do, is to have recourse to their pool of existing creditors. Because in most circumstances, or at least in many, some of those creditors will be banks and lending institutions. And many of them, it seems to me, will have a vested interest in a recoupment of part of the assets that the company in liquidation could recoup. And it may be that those sorts of creditors will themselves provide an opportunity for funding for the payment of lawyers to pursue proceedings such as these. So I think that is one route that we should expect to see. The other thing that I mentioned a little bit earlier that I'd come back to is this sort of Section 108A mechanism to make the process cost-bearing. And I think I could probably pontificate all on my own about whether that is likely to be seen more frequently or not. But I think all of you will have a greater experience of ever seeing that anyway. And I just sort of flag it to say that, you know, it might be something that we come to see. And even if we don't come to see it, maybe it's a useful strategy to offer it during the course of the adjudication soon after the notice, if only to revert to it later, and whether it might have some bearing on the definition of litigation expenses. The next option, it seems to me, is to consider BTE, so before the event insurance that might already be in place and that had been taken out before the company was made insolvent. And that might well provide some method of funding litigation. Another option, of course, is conventional retainers, just ordinary retainers that we would all be used to. Again, I raise the question of whether they could be deemed to be liquidation expenses and whether there is an interesting model there to explore in order to capture this work. Conventional retainers would, of course, make sense in cost-bearing proceedings, but I'm not telling you anything new there. And whether there will be arrangements or interesting agreements between lawyers and IPs in relation to the pot of assets overall, and whether that will lead into what I think the next heading is, which is CFAs, conditional fee agreements, CFA lights, as we call them, so those that are dependent on the amount that's actually recovered, and DBAs, dare I use that acronym, which should send fear into everyone if you hear that acronym. It seems to me that the client base here in this industry of lawyers should be thinking about these options, should be thinking about presenting a menu of options for the liquidator. Marion, I think I'm all right on time. I think I could go on for a bit. And should beware, though, if you're exploring those sorts of agreements, beware of the enforceability arguments. And of course, Meadows' side is an excellent example of that. CFAs generally are well-trodden territory. They're readily accessible to the drafting of them, and I imagine firms are well-versed in doing so. But even if you're not, and even if you are, frankly, there is always appropriate justification for getting some expert input into those. Yes, I am flying cost counsel flag there. And then DBAs, goodness me, you absolutely want to get expert input on the drafting and the operation of DBAs, because they are absolutely horrific. The regulations that govern DBAs are horrific, and of course Meadowside has shone a light on how, if you fall foul of the regulations that govern CFAs and DBAs, that in the end you fall back into champathy and maintenance. And the other things to think about in relation to that is that even though adjudication is not itself a cost-bearing arena, the type and nature of those retainers and how those agreements are put together, what the deal is between IPs and lawyers will be relevant. And it seems to me Meadowside is a perfect example of how adjudication is now susceptible to, in effect, a costs specialist attack on the retainer that has been used by the party that is representing or that makes representations in the adjudication. Because as you know how that has operated in Meadowside, it is to shine that light, say that it's champatous, and then as a result have it deemed to be an abusive process, and then say to the court at enforcement that it couldn't possibly look to enforce an agreement that is abusive. But whether that could be an argument that is taken before the stage of the TCC and before the enforcement proceedings, and whether it is taken as a significant point in the adjudication, seems to me to be quite an interesting question. But again, that might be something that I ask out of ignorance. Conscious of the time, other matters that I think are important to be reminded of. I think Bill Barton's asked a question about whether IPs will rely on ATE more and more, and it seems to me absolutely, and it seems to me that lawyers generally should be thinking about ATE after the event insurance premiums. Importantly, you should know in this context that additional liabilities, as we call them, so that being a title for success fees and ATE premiums, have been prohibited in terms of recovery from the loser. It's not prohibited to have them or have the arrangements and then recoup them from the client, but you can no longer recover them generally from the losing party. However, whilst most of the civil jurisdiction has had that change imposed upon it from the 1st of April 2013, in insolvency proceedings, the change is effective from 6th of April 2016. And I think that's really quite important and quite useful to remember, because I notice from my reading of these cases that the ability to stimulate the adjudication process or commence the adjudication process, it can be done at any time. I think those words "at any time" have been emphasised by the Bresco judgment. Finally, if you can ever deal with this, litigation funding, of course, presents yet another option. It's not champathy or maintenance if it's done properly. There are professional funders. You should be looking out for the hallmarks of members of the Association of Litigation Funders. Not only is it appropriate and regularly done in this jurisdiction, it's now seeing a lot more endorsement worldwide. We're seeing Canada and Australia all in recent months really endorsing the approach for litigation funding. You will have heard of the so-called Arkin cap, perhaps in passing, and the Arkin cap was thought to be an absolute cap on the liability of litigation funders. I'm wrapping up, I promise you, Marion.
Don't worry.
Was thought to be an absolute cap on the exposure to which a litigation funder could be put to by reference to the amount that it had funded. And that was thought to be a sound cap, but that has been recently displaced, firstly by Mr. Justice Snowden in Davey and Money at first instance, and then endorsed by the Court of Appeal. And various things that spoke to the departure in that case was the aggressive nature of the commercial agreement struck by the litigation funder, the multiple of sums involved in the way in which those agreements panned out, the priority of payment under the outcome of the litigation. That's also referred to regularly as the waterfall that these litigation funders impose upon everyone. And the litigation funder in that particular case had funded the entire case rather than just a part of it. There's not always a need for a CFA when you have a litigation funder, because the litigation funder will offer terms to pay the lawyers. But the problem with that is that the client then has to swallow a more bitter pill. They will look for a much bigger share of the overall win, typically between 20 to 50% of the amount recovered. Two last points. One, for the people that are watching this and that are thinking about litigation funding, there is a need to manage that tripartite relationship. So you've got a relationship with the litigation funder, and you've got a relationship with your client, whether it's professional or lay, but it is a relationship that needs to be managed very carefully. And there are agreements as between you as a law firm and litigation funder, and then litigation funder and client. And there have been some very interesting differences ironed out in very recent case law about the obligations. And I think there was another point that I was going to make, but I've gone for so long.
Well, don't worry about that, because I have learned a huge amount, I have to say, about what I didn't know about funding and costs. And David, can I ask you to pick up on the questions in the Q&A box? Will administrators and liquidators have to still produce security when seeking to enforce at the TCC? Because I think Lord Briggs, in fact, is very clear about that. And is there any difference as to how administrators and liquidators will be treated at enforcement?
I think that not all administrations are the same. And when you look at the statutory purpose of an administration as amended in Schedule B1 of the Insolvency Act, it's quite clear, and from my own experience, some administrations are to get companies back on their feet, back trading, and that ties in very neatly with, for example, interim payments and what the purpose of adjudication was about, which was to get money quickly through to contractors so they can keep the work going. On the other side of the coin, you have the other purpose being administration is simply to secure the best benefit for the creditors and to increase the size of the pool. And effectively, the company is hopelessly insolvent, and we're simply trying to get the most money for the unsecured creditors. And in those scenarios, I don't think there's going to be much difference, if any at all, when you're dealing at the enforcement stage and you're making an application for stay under Wimbledon and Vago principles. If a company is in administration, that is effectively a form of liquidation plus, and if a liquidator was making the application. Whereas there have been comments in a number of cases, if you have a CVA, for example, not all CVAs are the same. Some are light workouts to get the company back on its feet, and there's not going to be much of a problem if it eventually goes back into, if you try and overturn the adjudication in new proceedings, for example, then people can feel fairly confident that the company is going to be in a position to pay back any money secured in the adjudication. But I don't think there's going to be a huge, in most administrations, most liquidations, a huge difference being applied. But again, at that TCC stage, when you're coming to enforcement, we're going to be looking at the administrator's reports. We're looking at what's available, what's in the pool, what the different claims are, and what the prospects are of, if that money needs to be repaid, of getting all that money back. And just turning back to the Meadowside case, I mean, Lord Briggs did endorse what was said in Meadowside by Adam Constable, sitting as a deputy judge of the High Court. And I know John Dennis Smith and I spoke about this case a few weeks ago. The neutral citation of that is 2019, England and Wales High Court 2651 Technology and Construction Court. And when you read the decision, it's quite clear there's a number of hoops that a liquidator or another insolvency practitioner is going to have to jump through in terms of guaranteeing or making provision for the return of the money. It might be the case, of course, that the parent company of a company that's in liquidation is absolutely fine. They can offer those guarantees, and there's a real purpose for having an adjudication, in which case a decision like Bresco is fantastic, because they can give those guarantees, they can give those assurances, the ATE insurance if it's needed, would be happy to deal with that. I think Meadows' side of those aimed at a situation where someone has actually taken on a company's claims and is bringing them, hence the decision on championty. So if you are bringing a claim for a liquidator or administrator, given what Lord Briggs says about Adam Constable's comments in Meadows' side, it's worth going through those criteria and considering how it fits either your business model or the claim at hand.
Yes, because I think every time I go back through this line of cases, what is one of the often repeated themes, the mantras, is it's such a fact-sensitive jurisdiction. The moment we're dealing with summary judgment and stays, we're into discretion and we are into the real micro assessment of the facts of each case. And I think there's a tendency or a risk to think that there are overarching principles. Yes, there are, but they come up each time against the facts. And I think that we're going to have, as you say, David, to pick up on your theme, we're going to have a very interesting debate, in fact, as to the status of each company. Obviously, there's the formal liquidation, there's the formal administration, but then there's that penumbra when they're moving into that position, which is going, in fact, to be amplified by the bill that's just been put in Parliament. It's introduced, I think, on the 20th of May. Which is looking to, in fact, relieve companies and directors who are looking at insolvency because of COVID-19 and to protect them from that position. So lots of things to be looking at. Philip, general policy trends. Can you deduce that there are any general policy themes that we can take out of Bresco in the Supreme Court?
Yes, thank you, Marion. Actually, a footnote to the discussion on CVAs. The point was actually dealt with in the other appeal heard with Bresco in the Court of Appeal, Primus, and interestingly, even Coulson, who rejected the argument in Bresco, was in favor or found there to be utility in the average CVA. So I think that decision stands because it wasn't appealed. So that's probably the highest or latest authority on that. In terms of general trends, it's something really that you alluded to earlier, which is a pro-ADR view, at least on the part of Lord Briggs, but I would probably say other members of the Court of Appeal and the Supreme Court. And there are two pro-mediation decisions that come to mind where the Court of Appeal strongly reinforced the availability of cost sanctions for parties that didn't engage in that form of ADR. And the first is a decision from 2013, now a bit out of date, called EGF 2SA and OMFS. But the point was more recently reiterated by the Court of Appeal in Thakkar and Patel in 2017. And at a personal level, in a sense, I'd echo what you said about knowing your tribunal, because Lord Briggs has a track record of speaking on ADR and being involved in civil justice reforms, which may foreshadow this view in Bresco and the impact that it has on his reasoning. So, for example, he was the author, while still in the Court of Appeal, of the Civil Court Structure Review back in 2016, and since coming to the Supreme Court, he's given a number of speeches touching on this topic as well. Interestingly, though, as you say, the Supreme Court didn't decide the question on the extent of the parallels between arbitration and adjudication, in particular, the Fiona Trust point about the sort of validating interpretation and separability. And that's interesting because it was quite an important point in the Court of Appeal, because it then allowed Lord Justice Coulson to rely on what he considered to have been a concession. The Supreme Court didn't really deal with that, although on a close reading at paragraph 52, Lord Briggs does say, probably assuming that the concession was made or not, if it had been established, he would agree with Lord Justice Coulson that if something is referable to arbitration, the same would normally follow for adjudication. So there's a sort of flavor of it, but no firm decision. And just very briefly, and if we have time, I can develop this in question. The other point is that there isn't a huge amount of deference for specialist courts or judges sitting in the Court of Appeal with a long pedigree or experience of particular areas. And so you in the Supreme Court particularly, you can find yourself with a very experienced panel, but just one that doesn't have, say, experience of construction adjudication, as in Bresco, or another recent example is the case of Royal Mail and Duty, where a non-specialist panel with no employment or discrimination background reversed Lord Justice Underhill on quite an important point about motive and attribution. And Lord Briggs has done something similar in the significant case of Vedanta, disagreeing with some commercial court first instance decisions on whether England is the proper place or forum for service out in non-EU cases, or as to non-EU defendants more accurately. So really it is a sort of, not a free-for-all, I think that would be unfair, but arguments that may not find favor in the TCC or the Court of Appeal may well succeed on further appeal, because there is a sort of freshness in approaching the issues and a cross-cutting expertise, because Lord Briggs, of course, would have come at this from the background of an experienced chancery judge with plenty of experience, particularly with insolvency.
Yes, and it's so difficult to envisage anybody doing anything who sits in a judicial role which could be interpreted as being anti-alternative dispute resolution. I know the message we're being given is that there will be no backlog, or any backlog there will be closed down very quickly. But the reality must be that the existing trend to push into alternative dispute resolution will be maintained and encouraged. I think, David, you were saying that, in fact, this is something that cries out for statutory intervention.
Yeah, I was just picking up on Lady Justice Gloucester's comments in the earlier case of Wilson and Harbourview, where I tweeted about this earlier today. She makes it clear, we have the Insolvency Act 1986, and we have the Housing Class Construction Regeneration Act 1996, and of course, Sir Michael Latham's report, which led to Part 2 of the 96 Act, was in the light of the 86 Act, and yet we don't have a legislative steer as to how the two are supposed to interact. And Lady Justice Gloucester effectively said, this is judge-made case law. And yet again, Bresco and Lonsdale is trying to determine the way to navigate between these two pieces of legislation. It's something that we find in Australia and other jurisdictions as well, where you have, for example, in Australia, you have a corporate level of insolvency at the Commonwealth level, and constitutionally things like payment and construction adjudication being dealt with at state and territory level. And yet there's no ideas how the two are supposed to interface except through judge-made jurisprudence. Talking of judge-made jurisprudence, I was going to segue very unevenly into a question, a very important question, I think, that's been asked of the panel. Does what the Supreme Court say in paragraph 63 mean, as an adjudicator is asked to award a payment, potentially has jurisdiction to decide if there's defensive set-off to a claim of adjudication, any cross-claim that's within the scope of insolvency set-off, and then ask, is it sensible to place this burden on adjudicators, given the A and B, the adjudication nomination body, and the adjudicator may be unaware of a defence at the appointment stage? And this is something which I raised actually before we came on the air, which is Lord Briggs's rather ambitious perspectives, what the adjudicator can actually deal with when you have a notice of intention to appoint an adjudicator, which limits it to a particular dispute, and then a referral which is dealing with that dispute, and it's been brought by an insolvent company, but you want to raise as a cross-claim something which doesn't arise from that dispute, may not arise under that contract at all, and you try and bring that in as a defence. And I don't think the Supreme Court really gets to grips what the adjudicator is supposed to do in those circumstances. I think the adjudicator only has jurisdiction to deal with the dispute, and then we go back to the existing case law, but then any potential defence that can raise as a set-off can be dealt with, unless, of course, you have to put it in a notice, and you haven't served that notice. We get back into Grove territories we discussed earlier. But it is difficult. I compare it to, for example, if you ask for advice on a personal injury case, and then it turns out that when one car hit the other, in the boot of the car, a will got destroyed, now advised on the intestacy provisions. You just don't know what might turn up in a cross claim. And it's not fair for the adjudicator to have to deal with that. So it might be the case they simply have to leave it to one side, deal with disputes before then, and make declarations as appropriate. And I think, but then for a referring party, it has to be clear, if there are cross claims, you might not be able to enforce the decision, but you might be able to use parts of the decision as part of the entire process of working out the value of claims and cross claims as part of approving in the insolvency, which is really what Lord Briggs is trying to arrive at in the Supreme Court decision. And that's why Meadows' side, and Adam Constable makes it clear, if you do have substantial cross claims in the background, it's very, very unlikely you'll be able to enforce at the enforcement stage.
Yeah, I mean, the message is you've just got to get those out and on the table as early as possible, because whether or not they're going to succeed in the adjudication, they are certainly going to be in play when it comes to the summary judgment day of enforcement stage. There's a question in the chat box where the point is made that in fact the backlog is in relation to cases involving witnesses. But it seems to me it doesn't matter which particular sector the backlog is. Anyone who is deciding a case in the TCC will be aware of the limited time they have to make available for anything because of the backlog they're going to have to deal with. And it's that that drives getting anything and everything that possibly can be cleared out of the way and into adjudication. We're almost at time. Before we get there, can I just ask, I mean, Shaman might not want to, but if he does, he's well in, we would be pleased to do it. Any lessons to be learnt on the presentation and prosecution of litigation in the TCC or on appeal from this? Any lessons? I'll kick off. I think that there is, one of my lessons is going to be to push for a Brandeis brief, which is the submission of statistical data, certainly on appeal, when it's relevant to the decision. It's a practice that's, I half understand from America, but when you accept from this that there was huge weight placed on the proposition that adjudication in fact was the final decision. And yet, as they recognized in the Supreme Court, they had no data to support that. They could refer to judgments, they could refer to textbooks, but they had no hard statistical data. I think they're right, but I'd be interested. Can I just poll that? Would you go into the chat box? Do you agree? Is your experience that, yes or no, that adjudication in most cases achieves a resolution of the underlying dispute, which becomes final? Is that your experience? Those of you who are still with us, yes, generally less, 19 times. It's a bunch of lawyers answering this. You know, you've got to sit on that. You've got to allow yourself the wriggle room. But interesting, it's not uniformly yes. And that's the one thing I think we might need, the gap we might need to plug. Philip, David, Shaman, do you want to add one lesson?
I would say in terms of jurisdiction, we're going to see some interesting arguments. We have to remember an earlier lesson in litigations. You're not allowed to save them up, store them for later. If you're going to raise a question about jurisdiction, like the disputes question we had earlier, about whether or not you can bring a cross-claim, raise it, bring it to the adjudicator's attention, let them deal with it, and whichever way they jump, try and raise it again at the enforcement stage if you think it's got legs. That seems to be what Lord Briggs is saying, but the problem is what you can't do, though, is to store it up and keep it in your back pocket for the summary judgment stage. bring it early, and then at least you've got it and reserve your position appropriately.
While I'm just checking the box, Philip, do you want to add anything? Shaman, do you want to add anything?
I was just going to say, I'd be really interested to see if the satellite litigation in relation to retainers is going to surface before the adjudicator. In other words, it's probably going to surface in the TCC, but I wonder whether it has any legs before the adjudicator. And I think that would be quite interesting, because that might be a mechanism of just delaying the outcome of that process if that's what's desired.
Okay. And Philip?
Yeah, I mean, a sort of more general point about the role that first instance decisions can have, because as I read Bresco, Meadowside and that sort of reasoning survives, whereas the Court of Appeals on the face more authoritative reasoning is just discarded. So I think it's a good lesson to see, just because the Court of Appeal says something is the case, even absent a pending appeal to the Supreme Court, the trend in first instance decisions is just as important and may give you greater insights into how particular issues will play out on more specific fact patterns.
An interesting insight as ever. I think we've managed to wreak enough havoc. I think we've answered the questions in the chat and the Q&A. Please do keep these questions coming. I think it's a debate that is going to last for a long time. But at this point, I'm going to ask Beth to put the slide up and say thank you very much indeed for participating.
Thank you very much.
Thank you.